Let's start it out with Kevin. He's from Steger. A little background on Kevin, Jesse. He's got 2 children, a 6-year-old and a 9-year-old. Okay, he's got a boy and a girl. He works as a medical tech. He earns approximately $60,000 per year. His wife is educated but refuses to work. She may be bipolar. He's not sure, and she's got some other psychotic issues, he believes. She refuses to seek treatment. He would like her to seek treatment, obviously. The question is, the marriage is dissolving. They're not getting along. All these issues that she has are causing a problem with their relationship. He's concerned about his children, too. So with that background in mind, he asks, he's considering fighting for custody. What is the best interest of the child standard, and what are his odds?
The standard is what's the best interest of the child. What's going to happen? And, she's educated, she doesn't work. I mean, I wish I had some more facts, but we have what we have here.
Yeah.
I don't know when she had worked last. I don't know whether or not that she got her education during the course of the marriage, whether or not, they paid for her education during the course of marriage, whether or not there's any student loans owing or anything.
I can fill in a couple details for you. She's a college graduate,
Yep.
but she didn't work during the marriage. They started a family right away, and she's been a stay-at-home mom.
And how long have they been married?
About 11 years.
About 11 years, okay.
Yeah.
So, you still have an issue because, look, here's somebody, even though she has a college degree, hasn't been in the job market. And so probably what's going to happen is that, she's going to need to get some training. And, I mean, that's the only fair thing. Remember, a divorce is an equitable division of assets and of liabilities and all that stuff. The court tries to do what they believe is fair and what's equitable among everything else. In terms of custody, now...
He's worried about his kids, remember now.
Well, he's worried about his kids.
She's got some potential mental illness issues that she will not seek treatment for, and it's starting to show some effect on the children. So that's his concern. He really doesn't want to strip the wife from her obligations and her ability to raise the children.
Right.
But it's a health issue now that he's concerned about. And will the court buy that, or will he just be denied?
Well, I hear that all the time. Oh, he's evil. Oh, she's evil. Oh, he did this, she did that. And, he drinks too much, she smokes too much, somebody drinks too much Starbucks. I mean, it could go on and on. Just because somebody has an infirmary like bipolar doesn't necessarily exclude them as being a custodial parent. What's going to happen is if there's a custody battle, it's going to end up costing them a ton of money, because what's going to happen is First, the court is going to send them to mediation. A mediator is an attorney, doesn't have to be an attorney, but someone who's had the appropriate training, generally they're attorneys, and he or she is going to try to help the parties reach an agreement as it relates to custody and or parenting time or visitation. We like to neutralize it instead of visitation. I mean, parenting time is really what it is. And sometimes that will be not successful, sometimes it'll be successful, sometimes it'll be partly successful. So after that, assuming that it's not successful, what's going to happen is that the court is going to appoint a guardian ad litem, which is an attorney who has specific training, and that person is going to go out and do an investigation and report back to the court on what he or she believes is in the best interest of the child.
And this is an independent third party that does not have any relationship whatsoever with the parties or the children?
That's correct. And there's 3 things. There's a attorney for the child, there's a child rep, and there's a guardian ad litem. Guardian ad litem really represents the children, but it's not the children's attorney. So that person, regardless of what the child or children may want, depending upon their age, they're not bound by what it is. They're bound by what they believe in the situation, and based upon their investigation, what they think is in the best interest. Child rep is a little bit different. It's a combination of guardian ad litem. Guardian ad litem will write a report. Guardian ad litem can be questioned at the trial. Cannot necessarily participate in terms of filing motions or anything like that. Child rep can do all those things, and except that person doesn't get questioned, doesn't write a report. A attorney for the child is just like an attorney for anybody else. Their children are their clients, and they're kind of bound by that. And so generally, though, some places, like in Will County, they'll appoint a child rep, DuPage, guardian ad litem, And that's kind of what it comes down to.